Hello and welcome to the Minimum Competence episode for Thursday, May 29th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have Trump pushing crypto and 401ks, a freeze on student visa appointments, and SCOTUS ethics questioned over mass recusals in a book deal case. Let's remember, truth is stranger than fiction, but it is because fiction is obliged to stick to possibilities and truth isn't. And read today's legal news. On this day in legal history, May 29th, 1979, U.S. District Judge John H. Wood Jr. was assassinated outside his home in San Antonio, Texas. Nicknamed Maximum John for his reputation of handing down the harshest possible sentences in drug-related cases, Wood had become a prominent figure in the federal judiciary's war on narcotics. His assassination marked the first killing of a sitting federal judge in the 20th century, a grim milestone that shocked the legal community and raised urgent concerns about judicial security. The investigation into Wood's murder quickly became the most extensive and expensive federal inquiry of its time. Attention soon turned to Jamiel Jimmy Chagra, a wealthy drug trafficker facing trial before Judge Wood. Fearing a life sentence, Chagra orchestrated the murder by hiring Charles Harrelson, a known hitman and the father of actor Woody Harrelson. Harrelson was reportedly paid $250,000 for the job. Chagra's wife, Elizabeth, played a key role in facilitating communication between her husband and Harrelson, and was later convicted in connection with the plot. Authorities used wiretaps, surveillance, and confidential informants to build their case. Charles Harrelson was eventually convicted of murder and sentenced to 2 life terms, though he maintained his innocence for years. Jimmy Chagra was acquitted of the murder charge, but later admitted his involvement in exchange for a lighter sentence in other cases. The killing of Judge Wood underscored the dangerous intersection of the judiciary and organized drug crime in the late 1970s. It prompted significant reforms in judicial security, including increased protection for judges handling high-risk cases. The case remains one of the most chilling examples of retaliation against a federal judge in American legal history. The Trump administration announced it is rescinding a 2022 Department of Labor directive that had discouraged the inclusion of cryptocurrency options in 401k retirement plans. The original Biden-era guidance had urged employers to exercise extreme care when considering crypto investments for employee retirement accounts. It signaled a shift away from the legally required neutral stance of the DOL's Employee Benefits Security Administration. The 2022 policy had also threatened an investigative program targeting plan sponsors who offered cryptocurrency either directly or through self-directed brokerage windows. This earlier approach significantly dampened growing interest in crypto within retirement planning, despite companies like Fidelity exploring such offerings. With the Biden guidance now repealed, the Trump administration hopes to renew momentum in this area. However, broader market enthusiasm for alternative investments in 401k has lessened in recent years, making the potential impact of this policy shift uncertain. The Trump administration instructed U.S. embassies and consulates to halt the scheduling of new student and exchange visitor visa appointments. This pause comes as the State Department, under Secretary of State Marco Rubio, prepares to implement expanded social media vetting for foreign applicants. According to an internal cable, appointments already scheduled will still be honored, but unfilled slots should be withdrawn. The administration is conducting a review of the screening processes for F, M, and J visa applicants, which is expected to result in new vetting procedures. This decision aligns with the administration's broader immigration agenda, which includes increased deportations and visa revocations. Critics argue that these actions infringe on free speech, particularly in cases where student visa holders have expressed pro-Palestinian views. A Turkish student from Tufts University, for example, was detained for weeks after co-authoring an article critical of Israel. Meanwhile, protests erupted at Harvard University, where students and faculty opposed both the visa freeze and the administration's recent move to revoke Harvard's ability to host international students, who make up about 27% of the student body. The government has accused Harvard of resisting policy reforms and challenged its global academic role. In a great piece by Mike Masnick over at Tech-Dirt, the spotlight falls on an unusual and troubling scenario at the U.S. Supreme Court. 5 justices recused themselves from a single case, Baker v. Coates, because of overlapping financial ties to the same book publisher, Penguin Random House. 4 of the recused justices, Sotomayor, Gorsuch, Barrett, and Jackson, have publishing deals with Penguin, which is a named plaintiff in the case. Alito also recused, though no reason was provided. While watchdogs like Fix the Court praised this as a rare display of ethical self-restraint, Masnick, and to my mind rightly, questions the broader implications of the move. If recusals due to publishing ties become the norm, the court may be unable to hear any case involving Penguin Random House, a massive player in media litigation. The publisher is involved in major lawsuits, including ones against the Internet Archive and various state book bans, and could soon be in litigation involving AI training data. If too many justices are conflicted out of hearing such cases, key legal battles may be effectively resolved by lower courts, potentially leading to inconsistent outcomes across jurisdictions. Masnick argues this is a symptom of deeper flaws in Supreme Court ethics. Justices have long accepted book deals, speaking fees, and gifts, often without disclosing or recusing appropriately. Now that some are finally acknowledging conflicts, the court risks becoming dysfunctional. His provocative solution? Expand the court to around 100 justices who rotate in panels, limiting the influence of any one justice and allowing recusals without impairing the court's ability to function. Until systemic reform occurs, we're left with a Supreme Court that either ignores ethics or freezes itself into inaction, neither of which bodes well for the public trust. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, get your facts first, then you can distort them as you please.